Michael Popok, Legal AF, another day, another loss for Donald Trump. He's not getting a new trial in the E Jean Carroll case, in which a jury of 9 people in New York already found that he had committed persistent defamation and awarded E Jean Carroll punitive damages for $83.5 million in total, along with actual damages. The Judge Kaplan has just denied Donald Trump's motion for new trial, motion to lower the actual damage amount, motion to lower the punitive damage amount, and to render verdict in his favor. I'm going to walk you through the order, but that's the headline. Now let's get down to the molecular level. I'm going to start from the back, which I think is the most interesting of the observations by Judge Kaplan, and work my way back to the front of this 18-page order. As the judge addressed the heart of the matter, the punitive damage award that was awarded by this jury of 9 people, a federal jury in New York, of $65 million. Donald Trump said, nothing I did, everything I did was garden variety, nothing was outrageous, nothing was reprehensible, nothing was wanton and willful, which are the standards for punitive damages, and the amount that was too high. This is what the court had to say about it. And he also reminded, Judge Kaplan also reminded everybody about what this case was about. First line on page 2, the jury in a closely related case previously found that Donald Trump forcibly sexually abused plaintiff E Jean Carroll in the mid-1990s and maliciously defamed her in an October 2022 statement. In this case, the one he's dealing with now, another jury awarded Ms. Carroll $17.3 million in compensatory and $65 million in punitive damages against Trump for defaming her in 2 other statements that he made from the White House on June 21 and 22 of 2019. That's what this case is about. Sometimes the judge calls it technical raping of E Jean Carroll by Donald Trump. Today he's calling it forcibly sexually abused. Has to do with the unique definition under New York law. Now let's go back to the reprehensible conduct. On the bottom of page 13 of the order, the judge says the jury was entitled to find that the, quote, degree of reprehensibility of Mr. Trump's conduct was remarkably high, perhaps unprecedented. This is the judge. Far from being purely defensive, there was evidence that Mr. Trump used the office of the presidency, the loudest bully pulpit in America and possibly the world, to issue multiple statements castigating Ms. Carroll as a politically and financially motivated liar, insinuating that she was too unattractive for him to have sexually assaulted, whatever that means, and threatening that she would pay dearly for speaking out. The jury could have found that Mr. Trump wielded his position as arguably the most powerful and famous man in the world to broadcast his lies to millions. The judge said it earlier in the brief, over 100 million of his dedicated followers, in an effort to destroy Ms. Carroll's credibility, to punish her, to deter other women from doing so as well. It could have also found that he continued his attacks for nearly 5 years, that it took this case to come to a jury verdict. The jury in this case, bottom of page 14 by Judge Kaplan, the jury in this case at least arguably was entitled, moreover, to conclude that Mr. Trump's continued defamation of Ms. Carroll, even during the trial, even during the course of the trial, the judge emphasized, in turn warranted a finding that he would not stop attacking Ms. Carroll unless faced with a significant deterrent, a critical function of substantial punitive damages award. That's why it's right in their name, punitive, punishing damages. But beyond his out-of-court statements disparaging Ms. Carroll, and this is the key for me of the brief, during trial, many of which were introduced in evidence, right? New evidence was being created during the course of the trial by Donald Trump acting out and speaking out because he wasn't gagged outside the courtroom, but the lawyers were smartly able to bring that evidence to the jury in real time. Never had a case where a client continued to manufacture damning evidence against them during the course of one of my trials. The judge went on page 15 to say the jury could have found that Mr. Trump's demeanor and his conduct in the courtroom itself. Now we're back to Donald Trump acting out in a courtroom and a jury observing it, exactly what we're watching down the street at 60 Center Street, where the criminal trial of Donald Trump's going on right now. We've done other hot takes on that. Now the judge is calling it out. The jury could have found that Mr. Trump's demeanor and conduct in the courtroom itself put his hatred and disdain for Ms. Carroll on full display. Mr. Trump, this is the judge's observations presiding over the trial, could be heard repeatedly complaining to his counsel about the proceedings, so much so that plaintiff's counsel twice requested that the court instruct him to stop. Let's stop right there. I had missed this the first time around. Apparently, when they were trying this case the second time, the lawyers, Haba, and whoever else was there at the time, lost control of Donald Trump. And they asked the court to instruct Donald Trump to stop because they had lost control. Mother's Day is coming soon. And if you're looking for a gift for mom, that's also a gift to Mother Earth, Lomi is the perfect option. Food waste isn't actually waste. It's a valuable resource for our planet. Lomi helps to transform food scraps into nutrient-rich food for your garden, houseplants, or yard. Instead of dealing with stinky, gross, buggy compost bins, you can simply transform your waste at the push of a button. Lomi transforms your home into a climate solution, lowering your carbon footprint and helping keep the planet a little greener and your home a little cleaner. All my food scraps, plant clippings, and even those leftovers I forgot in the back of the fridge can go back into my garden, helping me grow more nutritious food at home. Lomi promises to bring you the best possible experience every time you run a cycle. They are one of the only kitchen appliances that has a full, no questions asked lifetime warranty on all devices, and they don't stop there. Lomi looks after you from day one and beyond. When you purchase a continued subscription, you'll automatically get upgraded to a new Lomi device every 3 years. It feels great to know that I'm creating Lomi Earth instead of waste. I have a basically limitless supply of plant food for my garden, plus I'm helping save the planet. Don't miss out on your chance to get the best gift for yourself and Mother Earth. Order your Lomi today. Head to lomi.com/legalaf and use the promo code legalaf to get $50 off your Lomi. That's $50 off your Lomi. Head to lomi.com/legalaf and use code legalaf at checkout. Thank you, Lomi, for sponsoring this episode. Particularly, the judge cited to the trial transcript. He said the plaintiff's counsel's first application to the court concerning his interruptions, the court instructing Mr. Trump to take special care to keep his voice down when he's conferring with counsel so the jury doesn't hear it. And then the second application to the court's second warnings to Mr. Trump to contain his errant remarks. The judge goes on. In particular, during Ms. Carroll's testimony, the victim, the jury could have found Mr. Trump could be heard making audible comments that Ms. Carroll's testimony was false, that the proceedings were a witch hunt, a con job, and most notably that his earlier statements disparaging Ms. Carroll were true. And most dramatically, mere minutes after plaintiff's counsel began her closing argument. That's Alina Habba. The closing argument made by Robbie Kaplan for E Jean Carroll. Sorry about that. Robbie Kaplan making closing argument for E Jean Carroll. Mr. Trump conspicuously stood and walked out of the courtroom in the middle of this female lawyer's presentation of her closing argument to the jury about her client who had been sexually assaulted, maligned, defamed. He just walked out. The judge said the jury could have concluded that by doing that, conspicuously standing up and walking out of the courtroom for no apparent reason, save to evidence his disapproval, though he was present again when the court resumed later that morning and remained for his own counsel's entire summation. On this exceptional record, the punitive damages evidence passes constitutional muster. I think that was the most damning section of it. The judge basically adopted all that Robbie Kaplan, the lawyer for E. Jean Carroll, wrote in their briefs. He went in to describe how the lawyers for Donald Trump, again, and that's just to remind everybody, if you're playing the Trump on trial home game, it's Alina Habba and Michael Medallo, joined by John Sauer, who's now arguing for the United States Supreme Court on the issue of whether there's constitutional immunity from prosecution for a president for Trump, but he's also on the brief here. They also said, you got the law wrong. They argue in their Trump briefs that you have to show a higher level of malice, constitutional actual malice, before a jury can award those damages. And the judge says, we're under New York law and not federal law. And under New York law, as expressed by the Court of Appeals, the highest court in New York, and as affirmed time and time again, common law malice is what is required. And common law malice is an instruction he gave to the jury that if they find that the defendant with deliberate intent to injure or out of hatred, ill will, or spite, or with willful, wanton, or reckless disregard of another's rights, they can award punitive damages. That's all New York law applies. He just said, Judge Kaplan, later in the brief, the jury could have seen his ill will and spite towards E Jean Carroll on full display the way he acted in the courtroom, let alone the issues that were present there. So they said, first thing, you got the law wrong. New York law, Court of Appeals, and the Second Circuit, which is his bosses at the appellate level for the federal court, they've always adopted the common law malice instruction related to that. So he spends a lot of pages talking about that. He says, as to your attack on the standard of proof, there's a burden that all parties have to make in civil court as opposed to criminal court. Little Patreon breakout session here. It's not at the highest level. It's not beyond a reasonable doubt. It's generally what we call a preponderance of the evidence. It's easier to prove your case in civil court than criminal court. A plaintiff in civil court, like E Jean Carroll, just has to show on two equally balanced scales of justice that the weight of the evidence just tips ever so slightly in her favor. It's the feather on one side of two equally balanced scales. That's it. That's preponderance. So Trump's brief said, you have to instruct it that it has to be proven by clear and convincing evidence before punitive damages can be awarded. And it just says, I don't know what you're talking about, but for the last 100 years in New York, it's not new law. The courts for 100 years applying the Corrigan case have said that it is only a preponderance of the evidence, and that was the proper standard that I provided. So another attempt at arguing some sort of reversible error that failed. And so all of the judge then ended his brief by comparing the compensatory damages, the non-punitive damages that were awarded for $17 million to E Jean Carroll, with other similarly situated cases precedent in the past, and many of them from 10, 15, 20, and 30 years ago. And when he ran all those amounts that were awarded and found to be fine forward under present dollars, under 2024 dollars, the $17 million that was found kind of fell right in the heartland of what was appropriate. It has been found to be appropriate by other courts. And so he wasn't going to take away the jury's right to establish the right amount of consequential damages, having found that they did it right and the number they came up with was right. Punitive damages stay, actual damages stay, rejection of a new trial, and now Donald Trump can try to take his full appeal to the Second Circuit Court of Appeals. He's already posted his bond. As we know, there is an appeal that's there now, the $83.5 million. I think he had to post close to $100 million for the two cases. The way the bonds work is if he loses on appeal, that money can go, if he doesn't pay the judgment within 30 days, then E Jean Carroll can just go get the bonds and have that paid to her as compensation. And those bonds are updated as time goes on to make sure they're carrying enough accrued interest so that the judgment creditor, who is E Jean Carroll, she has two judgments against Donald Trump, is protected. We'll continue to follow everything about E Jean Carroll. It's not just what's happening in the criminal courts with Donald Trump. It's the civil courts, the $465 million civil fraud judgment that's up on appeal. It's this $100 million of E Jean Carroll damages that's up on appeal. That's important as well. And we'll bring you these developments at the intersection of law and politics. Then we bring it all together in a show we call Legal AF. That's New York for you every Wednesday and Saturday at 8 p.m. Eastern time. You want to know why we call it Legal AF? Join us and we'll tell you. So until our next hot take, until our next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.